Christopher Orengo, for Belfast. Orengo Vincent, Orengo, Moses Osoro, Counsel Mwanga, Donna Dorina.
Okay.
Prosecutor.
Sorry, for prosecutor. It may please the court, my name is Orengo. I appear for the respondents, together with my lovely friends, Faith Odhiambo, former president of the Law Society of Kenya, Honorable Babu Owino.
Morning, Your Honor.
Mr. Nyauke.
Morning, Your Honor.
Morning.
Mr. Mowo. Present. Mr. Andina.
Present, Your Honor.
And Mr. Opatu.
Present, Your Honor.
The last one is Mr.
Opatu. O-P-A-T-U. We are paying for all the responses.
Your Honor, Ms. Rupia, I appear for the applicant. Your Honor, my instructions are that if the court is pleased, we can close this file. The investigations have been concluded and the DPP will not be charging them for murder. The file is pending approval for malicious damage to property and preparation to commit a felony. So we are praying that the file be closed.
Please, in court 12.
Yeah, it's in court 12, so actually I'm not supposed to sign that sheet. But I'm here, so they are supposed to go today for please.
Si utatusaidia, tuko na flight ya kurudi Nairobi, please. Yeah. But itanunia haraka.
Kuna mwenye already ananisaidia, so zitaletwa kisaidi like shortly.
Okay.
Ndio tumalizane nao.
But tutaenda nao another court.
Yeah.
Wapelekwe
I have another question. Since they are supposed to be going for free, the court are in the cells just for the free. Because to order for? If they can be held in the cells just for today, because the file is supposed to be brought for meeting.
Can she do that without a substantive application? I mean, this is very casual. They knew this matter was coming today. They require of you to make an order. And in effect, what she's telling you is to hold them without charge, or yet another day which will become another week or another fortnight. There should have been some material before the court. And if there's material before the court, we'll be able to interrogate that material. So I respectfully ask the court that we deal with her application, the first application. She had the advantage, or the prosecution had the advantage of appearing before this court on 13th of July and persuaded the court to help the respondents for 15 days. In fact, they were held for a period longer than the prosecution asked for. And for a period of more than 14 days. So, Your Honor, let's deal with the application, fast application. And if you find merit in that application, then we can proceed on the basis of the ruling on that fast application. Yeah, I can give the citation later if you can remember the case against the Deputy Chief Justice of the Republic, Honorable Will. She was brought to court on a variety of charges. And when the court determined that there was a violation of the Bill of Rights, those charges were terminated. Your Honor, we want to demonstrate to this court that the proceedings and the issues that arose during the proceedings of this current application were in violation of the Constitution and the Bill of Rights. So the foundation of the case that we propose to bring against the respondents violated the respondents' constitutional rights, Bill of Rights, and the owner should not make any further orders other than their release, and direct the police not to touch them until there's a proper charge from the court. You can already hear all the mischief that please hold them for another day on a charge that we don't even have the copy of the charge. You're being told, hold them for another day. And forget about what has happened in the proceedings subject matter of the miscellaneous application. So we want to address you at some length on why the prosecution should not trample on the constitutional rights of whoever appears before the courts or outside the courts. The Bill of Rights extends to those in custody, lawfully in custody. It extends to arrested persons, and is the foundation of our constitutional order. You know, I didn't know this was going to happen, but just 3 weeks ago, Honorable Babu and I appeared in a court where a person was charged with treason. There can never be a more serious charge than treason or murder. And held in custody for nearly 3 weeks. the court declines to give them any further opportunity to abuse the rights of the accused persons. We have been waiting for those prison charges. Only Bobo Win is here. We have been waiting for those prison charges. They have never come. And to impress the court, they were talking about a murder case. The principal application was made on the basis of a murder charge, which was in the affidavit and the application, was the first charge referred to. There is not going to be a murder charge. In fact, from what I've heard of her, there is not going to be a murder charge. So that charge was put in the application. So, to persuade the court that there was a serious charge, that the court needed to consider in determining whether to release them or not. In conclusion, I just want to talk about two things. You should ensure there is no abuse of the court process. And only I'm saying this because before you, there was a submission that the respondents are likely to interfere with witnesses. It is fight law that on that issue, the prosecution should not make any submissions which is not supported by evidence. Material evidence to demonstrate that they are more information that the respondents are likely to interfere. There are flight risks. Normally, a judicial court cannot make a judgment on that question without material evidence. So what is the court to do in these circumstances that we find ourselves in? I think one, as has been prayed by the prosecution, is to close the file. And secondly, because there's been an abuse of the court process, in effect that there was going to be a charge and there's no charge, and the prosecutor has clearly indicated that the respondents should be held until a charge is filed before the court, a charge which has not been approved. We pray that you make an order that when such a charge is filed before the court, because the charge has not been approved, but if such a charge has been approved, I'm ready for registration of file in court. The respondent should be served with summons to appear. Either through counsel or through the respondents themselves, or both. so that the accused, the respondents should not again suffer pre-trial detention.
Daddy, you know, call you up.
Which they have already suffered 15 days of pre-trial detention without an indictment or without any charge before the court. Just to defend and protect the principle ingrained in our Constitution of presumption of innocence. It should find it on the court that they should be summoned when the prosecution is ready, the matter is properly before the court. So that we don't have some fictional release, is playing around with justice. That they walk out of this courtroom and on the steps of the court or within the court presence, they are again arrested. I think that will be playing around with the justice system. We pray.